Good evening. I'm Divya M J. Currently, I'm doing LM at Government Law College, Trivandrum. So, the duty entrusted to me is to take a review class on the topic Union and State Legislature and Distribution of Legislative Powers. As we all know, legislature can be divided into two main heads, namely the Union Legislature and the State Legislature. Article 79 says that a parliament shall consist of a president and two houses, namely the Rajya Sabha and Lok Sabha. Coming to Article 80, which deals with the composition of Council of States, that it says that it shall consist of a total of 250 members, out of which 238 members are elected by the members of legislature of the state and union territories, and 12 members to be nominated by the president among persons having special knowledge and experience in literature, science, art, and social service. The tenure set in the Constitution is 6 years, and the meeting shall be presided by the Vice President and, in his absence, by the Deputy Chairman. Any citizen who have attained the age of 30 years and other sufficient qualities or requirements prescribed with the Constitution is eligible to become a member of Rajya Sabha. We have discussed what will be the procedure or who shall preside the meeting in the absence of the chairman, that is the deputy chairman. If the deputy chairman is absent, a member from the panel constituted under the rules of procedure and conduct of business in Rajya Sabha will preside the session. That is, a member from the panel of vice chairman will preside the meeting. Then, coming to the composition of Lok Sabha, it is dealt under Article 81. It says that it shall consist of members not more than 550 in number, out of which 530 members are chosen by direct election from territorial constituencies in the states and 20 from the union territories. It is to be noted that the 104th Amendment has amended Article 334 to cease the reservation of Anglo-Indians in the Lok Sabha and in the state legislative assemblies. The tenure of the members of Lok Sabha is 5 years, and the meeting shall be presided by the Speaker and, in his absence, by the Deputy Speaker. If the Deputy Speaker is absent, then a member from the panel constituted under the rules of procedure and conduct of business in Lok Sabha will preside the meeting. Simply, a member from the panel of chairperson will preside the meeting. Then coming to the Article 85, which deals with sessions of Parliament, prorogation and dissolution. The President shall from time to time summon each House of Parliament to meet, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. Then Article 86 deals with right of President to address and send messages to houses. Article 87 deals with special address by the President, and also Article 88, it deals with right of ministers and Attorney General as respect houses. Here, every minister and the Attorney General of India shall have the right to speak in and to take part in the proceedings of either house, any joint sitting of houses, and any committee of Parliament of which he may be named as a member, but shall not be entitled to vote. Then Article 90 says that a member holding office as a deputy chairman of the Council of States shall vacate his office if he ceases to be member of the council, resign by writing address to the chairman, removed by a resolution of the council passed by a majority of all the members of the council, provided at least 14 days notice has been given of the intention to move the resolution. Then Article 94 deals with the vacation and resignation of and removal from the offices of Speaker and Deputy Speaker. Same as in the case previously mentioned, that is 14 days prior notice shall be given. Article 100 deals with the voting in houses to act notwithstanding vacancies and quorum. Article 100 clause 1 para 2 says that the chairman or speaker or persons acting as such shall not vote in the first instance, but shall have and exercise a casting vote in case of equality of votes. Now let's have a look into the disqualification for membership, which is dealt under Article 102. It says that this disqualification is meant for both houses of the parliament. That is, firstly, if he holds any office or profit under the government of India or the government of any state. Secondly, is of unsound mind and declared so by a competent court. Thirdly, an undischarged insolvent. Next one is that if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state. The provisions as to the disqualification on ground of defection mentioned in the 10th schedule shall be kept in mind while discussing the disqualification of members. Then coming to the state legislature, which is dealt under Article 168 to 212, it shall consist of a governor, legislative assembly, and legislative council. Saying about the legislative council, it consists of not more than 1/3 of the total number of legislative assembly, and in no case less than 40. 1/3 members will retire every 2 years, and the tenure said is 6 period. The session shall be presided by a chairman who is elected from among its members. Any citizen who has attained the age of 30 years and possesses such a qualification prescribed by law can be a member. Saying about legislative assembly, it shall consist of not more than 500 members and not less than 60 members, chosen by direct election from territorial constituencies in the state. The tenure mentioned is 5 years, and the meeting shall be presided by the speaker or deputy speaker elected among them. Any Indian citizen who attains the age of 25 years and possesses such other qualification prescribed by the law is eligible to be elected as a member of Legislative Assembly. Article 105, 194 and 361A deals with privileged communication. Legislative procedures are dealt under Article 107 to 117 and Article 196 to 207. Article 222 and 212 deals with restrictions on court, and finally Article 121 and 211 deals with restrictions on legislature. Now let's have a look into the three lists. Firstly, union list. It consists of 97 items having national significance, and only the Indian Parliament is capable of legislating on these matters. Some of the important items in this list are defense, Central Bureau of Investigation, corporation tax, preventive detention, war and peace, citizenship, highways and railways, etc. Coming to the state list, it consists of 67 items relating to local interest, subjects of local interest or the interest of the state. Some of the important items dealt in the list are public order, local government, public health and sanitation, agriculture and fisheries. The third list or the concurrent list, it consists of 47 items with respect to which both the Union Parliament and the state legislature hold a concurrent legislative power. In case a dispute arises in relation to any subject contained in this list, the Union legislature shall prevail over that of state. Some of the important items dealt under the third list are criminal law and procedure, marriage and divorce, transfer of property, contempt of court, except that of Supreme Court, then civil law and procedure, legal, medical and other professions, electricity, etc. Now let us have a look into the reasons why the Parliament is so sovereign. It is to be noted that Article 245 to 255 of the Indian Constitution deals with the distribution of legislative powers. So let's have a glance at the important articles among them. By virtue of Article 247, the Parliament is empowered to establish courts or judicial bodies for better administrating the laws passed by the Parliament or relating to any laws under the state list. The most important one is the residuary legislative powers dealt under Article 248, That is, the Parliament has the power to make laws in relation to any matters which is not present in either the concurrent list or the state list, including the power to make laws on tax imposition. Article 249, it deals with the parliamentary legislative power with respect to a matter in the state list in the national interest. Coming to Article 255, it says that during emergency, the Parliament has the power to make any law with respect to any matter in the state list, and such law shall be applicable only a year after the emergency is withdrawn. Article 251, it deals with the inconsistency between parliamentary legislation under Article 249 and 250 and laws made by the legislatures of the state. If any legal provision legislated by the state legislature is repugnant to any legal provision so legislated by the parliament, then the law made by the parliament shall prevail over the one passed by the state, and the state legislation shall be imperative until the operation of the parliamentary law. Article 254, it deals with the inconsistency between the parliamentary laws and the laws made by the legislature. Similarly, the law made by the parliament will prevail. That's all about the topic union and the state legislature and distribution of legislative powers. Thank you.
Thank you, Divya. Officer, on to you.